State of Wisconsin versus Theodore Edgecomb, 20 CF 3535. Appearance.
Great Shooter for the state.
Afternoon, Your Honor. Anik Ahmad on behalf of Theodore Edgecomb.
B.I.V. Lamar also on behalf of Theodore Edgecomb.
All right, the case is here today on a number of motions, some motions in limine, some other issues that need to be addressed. I'll hear from both sides, but I think the first one in date order was the issue of the defense asking to call Mr. Burrams, B-U-R-E-M-S, and the state objecting at least to, if not the testimony or the expert, at least some of the testimony. Any reason we should start with something other than that?
However the court wants to begin with it.
All right, well, why don't we start with that one? The defense named him, the state's objecting, so why don't I hear the state on the objection to calling Mr. Burrams? The objection being that apparently Mr. Burrams wants to allegedly testify that the force used or the behavior of the defendant in the day in question was, quote, reasonable, end quote. Go ahead, Mr. Huebner.
Yes, so, Your Honor, I filed a brief. I don't necessarily want to get too much more into it, but I would just simply indicate that under Wisconsin law, Detective Burm, or former Detective Burm, Mr. Burm's testimony as to pretty much everything as to the self-defense, it's not admissible. Law of self-defense is defined in statute, and Wisconsin Jury Instruction 805 clearly describes how that's going to be delineated to the jury. It involves the jury making decisions as to whether or not the defendant actually and then reasonably believed that there was an actual or imminent unlawful interference, then that he actually and reasonably believed that the amount of force used or threatened to use was necessary to prevent or terminate interference, and then the last one was that it was reasonable. The question we have here in this is the state of Wisconsin's Court of Appeals has defined self-defense then as having two components. One is subjective, which means he actually believed, and the second is objective, which is what the jury has to determine whether or not said beliefs were reasonable. And this spells out in this case because, and as the court knows, we still haven't amended information. So this will spell out first-degree intentional homicide. If he actual and reasonable will be spelled out to the jury and how it plays out into lesser included of second-degree intentional, first-degree reckless, second-degree reckless. The defendant is the only person who can testify as to what he actually believed. Mr. Burm's opinions, they're irrelevant as to that. Whether or not Mr. Burns believes that the defendant actually believed it, it's irrelevant. No witness is allowed to testify as to what another person believed, or more importantly, what the defense is attempting to do with Mr. Burns is to get him to say that the defendant is being honest about what he's saying, and you can't do that.
Right, let me jump in. That's clearly the law. So defense have something I'm missing? Because that's absolutely correct. No witness gets to say another witness's actions, in this case the defendant's actions, were reasonable. They don't get to comment on the accuracy or validity of a defendant's statements. They don't get to put themselves in the position of the jury. The state's correct on the Richardson case.
Your Honor, first we'd like to bring to the court's attention that Ricky Burrams was to testify on two different issues. The first issue involving investigation and the standard norms involving the Milwaukee Police Department is not at issue, but we did want to kindly note that Ricky Burrams was to testify on two issues. As to the second issue that is brought by the state's objection regarding the reasonableness of Mr. Edgecomb's force, we would concede that Mr. Burrams to not provide testimony as to the ultimate issue as it relates to the reasonableness of Mr. Edgecomb's use of force. However, we do believe that Mr. Brooms should be able to testify as to potential threats, what a use of force is, the use of force consortium. We believe that his testimony would be helpful for a jury's understanding of to at least what constitutes a threat in that regard. That would still allow the jury to be able to decide the ultimate issue as to the reasonableness of Mr. Edgecomb's actions. So for that purpose, we have conceded with the state as to the ultimate issue as it relates to the reasonableness, but we believe that Mr. Brooms should be able to testify as to at least what constitutes a threat. He has, substantial experience in that issue, working as a Milwaukee Police Department homicide investigator, has testified numerous times in this court. So for that limited purpose, we would ask the court to allow his testimony for that.
Your Honor, I'm going to object to that as well. They're stating they want Detective Brooms to testify as to what is a threat, and then to also testify in their moving papers as to the continuum of basically what they're referring to as what an individual law enforcement training is in the continuum of the use of force. First of all, Detective Brooms testifying as to what something is or is not a threat is simply them attempting to get Detective Brooms to say that the defendant is telling the truth, that he thought it was an actual threat.
Right, which is not going to happen. That is not going to happen. No witness is testifying to that, period.
So there are citizen witnesses, as well as, there's 4 of them, as well as the defendant. All of them can testify as to what they saw, but no witness can testify as to whether or not, even those 4 that are there, that they thought someone was acting in self-defense. They can testify as to, what people's demeanor were like. They can testify as to how actions were, but they can't, no witness can sit there and state that they thought something was threatening to the defendant. The only person who can do that is the defendant. They can describe what they saw, and then it's for the jury to decide. The next thing the defense wants is for Detective Brooms to talk about the continuum of use of force. That's irrelevant. This defendant is not a police officer. He doesn't have that training.
Well, hang on. I presume by the continuum of use of force, that would mean a police term, correct me if I'm wrong.
That's correct.
Of you do this first, then you try to de-escalate the situation with maybe your words, then you use bodily force, then maybe use a nightstick, then maybe a taser, then maybe a gun, something along those lines?
I believe so. It's not spelled out as to what the defense is referring to, but considering Detective Brooms is a former Milwaukee police detective, I believe that's what they're referring to. But this defendant is not a member of the Milwaukee Police Department. He's never received that training. As far as I know, he's never received any training. As far as I know, he's never even gone to a concealed carry permit class. So that training is irrelevant as to this defendant. What matters is what this defendant, at that moment, what he is going to articulate and what witnesses saw. That's it. What may have happened in some Milwaukee Police Department training and how a Milwaukee police detective states that a Milwaukee police officer would have handled that situation is irrelevant for the jury's decision as to what the defendant was doing that day. So all of that from Detective Brooms' testimony is irrelevant. It should not be brought in. The case law is very clear. The first part, yeah, if that's what they want to bring in and have him testify as to his expertise as a homicide detective and certain things that he thinks should have been done, fine. They can call him as to that. But attempting to get this jury to evaluate whether or not the defendant actually believes something and then reasonably believes something based on Milwaukee police training he never got is irrelevant, and therefore it should not be allowed in.
Yeah, and if we could respond briefly. We've already conceded on the issue of Mr. Brooms testifying to the ultimate issue, so that's not at stake as it relates to the reasonableness. However, Mr. Brooms has testified. He's actually been called by the state on numerous occasions, over several hundred homicide cases, and testified to what constitutes a threat. So, he was obviously credible in when it was the state's interest, but now he's doing it so on the defense side, and now the state takes issue at that. A threat is still a threat. He's not testifying as to reasonableness of Mr. Edgecomb's actions. He's only testifying to what constitutes a threat. period. That's all that we're asking for. We've already conceded as it relates to the reasonableness issue. As it relates to the use of force continuum, that is, we understand that to be a continuum that is basically reasonableness. It constitutes reasonableness for an officer and also for dealing and de-escalating situations. Obviously, if a jury is to consider what is reasonable, that could be helpful. But even if the court decides that the use of force continuum evidence should not come in by Mr. Brooms, as it relates to what constitutes a threat, again, Mr. Brooms has testified several hundred times in this court for the police department on those issues, and he should be able to do so when it's a defendant at issue.
Your Honor, I would like the defense to name me one case where Detective Brooms has taken the stand and stated to a jury that he believes something was a threat to an individual. Name one.
So, hang on, so would I.
Well,
A case number that occurred in Milwaukee County.
well, the state hasn't asked for any type of addendum to Mr. Brooms.
Counsel, I'm asking.
Well, Mr. Brooms is not here right now, but
Hang on, counsel. You just represented that he's testified hundreds of times in this court. For me, this court means me. I don't care what happens in front of other judges. I don't care what happens down the hall. I'm presiding over this case. I will make the rulings. So as far as I'm aware, he's never testified in front of me. And I don't recall ever hearing testimony along the lines of what you just indicated. So unless you have a case number that I can look up in Milwaukee County, but particularly one that was in front of this judge, then forget it. You guys cannot just make blanket allegations from the defense without supporting it. You didn't support it in writing, and now it's not being supported on the record. That was a valid request. Name a case now, or we're moving on.
Mr. Brooms can testify to the cases that he testified in.
Name the case now.
We don't have the information.
And he's not
at our
testifying
disposal right now.
Then he's not testifying.
As to that issue, Your Honor,
Counsel, right now, he's not testifying at all because you guys have not given me anything that would indicate he can provide relevant testimony to this trial.
well, Your Honor, we'd ask that we would have a Dauber motion where he would be able to provide such testimony.
I don't honestly see the point of that.
I mean, he's testified in several cases.
Counsel. He's done it with other judges' argument does not work with me. Mr. Huebner knows that. Mr. Ahmad should know that. I don't care what other judges have ruled. Period. Now, if the Court of Appeals has made a ruling, fine. If the Supreme Court has made a ruling, fine. But just because someone allegedly testified in front of a colleague on a nameless case where I don't know what the merits of the case were, I don't know what the allegations were, was it a homicide, was it an armed robbery? You can't just throw things out there like, well, he's testified hundreds of times. I've never heard his name. He may have at some point testified in front of me because I've had hundreds of homicide trials. But he's never given testimony like that. Mr. Brooms is not going to take the stand and say that your client's actions were reasonable or that they were unreasonable. That is the province of the jury, period. Let's move on.
Your Honor,
If Mr. Brooms and the defense had better provide some documentation by the end of the day tomorrow, because on top of everything else, gentlemen, I'm tiring of you guys filing document after document after document. We had a hearing 2 weeks ago, and every day over the Christmas to New Year's holiday, another document came flying in. Additional motions limiting, new experts, supposedly new witnesses that were found. I'm tiring of it. If I get some documentation, Mr. Brooms could potentially testify about the investigation that occurred or took place by MPD. That's the end of it. Was it an adequate investigation? Yes or no? Was it thorough? Yes or no? But he's not going down the other two paths, period. It's inappropriate, and you guys know it's inappropriate. Next.
Your Honor, and I don't know if defense counsel would have potentially another thing that they would like to discuss, but I think potentially the next most important motion eliminated by the defense was their motion to exclude a portion of the poll cam video. The court, we heard arguments on this. The court stated that it would make a decision. It needed a little bit more time. My suggestion here is and just so the court will remember, this is the video that happens and captures what happens seconds before the one video that we've all seen, which captures the homicide. But right around that corner, there is the confrontation in which the defendant punches the victim in the face.
Right, I've paid attention. There's allegedly 3 confrontations. Some confrontation allegedly that's not caught on camera.
Correct.
A confrontation where the defendant punches before we get into this argument later, punches the victim, punches Mr. Cleereman through a window, apparently. Then there's the confrontation that ultimately is the fatal confrontation, right?
Correct. And I'm almost positive the defense is not attempting to prevent us from using the video that shows the actual homicide. There is an argument that the defense is making that the video that shows the punch is unduly prejudicial over its probative value. What I would suggest at this point is, could we potentially show the court the video? And because the court hasn't made a ruling on it, and I don't want, in case the court rules against me, I don't want this video potentially out there in a way in which the jury could see it. I've got my computer, I've got the CD, we can all go into chambers right now, I can play it for the court, and then we can talk about it. Is that fair?
Defense have any objection to that?
No, Your Honor.
Okay.
Fine. All right, I forgot where we left off exactly. I had a conversation off the record with the attorneys.
Your Honor, where we left off was we were going to be taking up the defense objection to the playing of the first segment from the poll camera.
Right.
There are 2 segments. One we're very familiar with, but the segment that happens right before it, the defense was objecting as to it being unduly prejudicial. The court has watched it now.
Right. Thank you for the reminder. We discussed a couple of different things after doing that. So yes, for the record, I viewed the video that's in question between both sides. There are allegations in this case that there were effectively 3 confrontations. A confrontation between Mr. Edgecomb and Mr. Cleereman that was not caught on video, that was on Brady Street somewhere east of where the ultimate incident occurred. Then there's a video that I just watched that shows the defendant apparently punching, it would appear, the victim, Mr. Cleereman, through the window of the vehicle. And then Mr. Huebner has represented to me that that occurs, and I'm familiar with the area, within seconds, maybe 5 or 10 seconds of what ultimately leads to the fatal confrontation 5 or 10 seconds later, which is just around the corner from Brady Street, as I think they turn onto Holton Street, or at least the bridge that leads to Holton Street. I viewed it. I'll hear from the defense if there's any argument, or if you want to elaborate, please.
Yeah, we're just going to put on the record, Your Honor, we do believe that the video would tend to confuse the jury. We do know the court is, predisposed to admit the video, but we want to just put on the record that we do think the video is unfairly prejudicial on the basis that it would tend to confuse the jury. There was an incident that preceded that altercation, and without, of course, the defense is reliant on the Milwaukee Police Department and its investigators to obtain the video of the first altercation, which has not happened, which the Milwaukee Police Department has failed to do. Therefore, the video that's at issue tends to make it look like Mr. Edgecomb was the initial aggressor without that first video. Again, we do understand that the court is, intends to admit that video, but we want to put that on the record that we do feel like it is unfairly prejudicial.
So noted. I'm allowing the state to use that video that I just watched. It's the video that shows allegedly the defendant punching Mr. Cleereman into or through a car window on Brady Street. It's probative. It's, I guess, prejudicial, but as the lawyers know, all evidence is designed to be prejudicial, but it's not unfairly prejudicial. It's part of the continuum of this incident that occurred. The lawyers discussed or implied that Mr. Huebner might make it seem like that was the initial confrontation. I'm confident Mr. Huebner would not do that. I would hope and expect that the state's going to call a witness or witnesses that will indicate that there were, depending on how you look at it, 3 confrontations. One that was not caught on video, then the second confrontation that was caught on video, the punch, and then 5 or 10 seconds later, when there's a turn onto, again, Holton Street or the bridge, what results in the ultimate fatal confrontation. So the state can use it. It's not unfairly prejudicial. It's part of the continuation or continuum of this incident and what occurred over the course of 30 seconds or a couple minutes, all of which the jury should be able to see and weigh appropriately and effectively as they deliberate the allegations in this case. There's a number of motions eliminated. Was there anything else, Mr. Huebner, you wanted to address before I turn to the defense motions?
Well, yeah, these are basically all defense motions, so we can just deal with them.
Basically, yes, but so the defense filed 3rd motions in limine. The first motion in limine is requesting exclusion of photographic evidence due to the danger of unfair prejudice. Number 2, that's the haircut issue, getting the defendant a haircut. Number 3 is an issue regarding how the state addresses various individuals during the trial, individuals and other persons, either that are testifying or may be referred to during the trial. And then number 4 is the testimony of a potential witness. I'll hear from the defense on the exclusion of photographic evidence, but I'll just say this. I mean, I've tried by now, I'm sure 100 homicides in my career, if not 100, at least 75 or 80. The state gets to put in evidence that is sometimes gory. It may include a dead body. It may include someone who, I mean, I've seen people that have been stabbed to death, people that have been shot in the head, people that have had rigor mortis set in because their body wasn't seen or found for a few days. The state can introduce that. They can't belabor it. They can't introduce 15 photos of a dead body, because I'm not going to let them turn this into an attempt to, obviously, as the defense mentions, disgust the jury or make it more difficult for the jury to be fair and impartial. But the state gets to introduce the evidence. Usually what I allow is anywhere from 2 to 4 or 5 photos. I've never allowed a state to, Mr. Huebner or anyone else, to belabor it. The state may have 20 or 30 photos of the deceased. They're not going to introduce all of them. Having said that, is that enough of a ruling, or do we need to discuss it further? Mr. Huebner?
Well, Your Honor, what I will say is I've given defense counsel the numbers. I sent them, they already have the CDs, and then I emailed them all the numbers that I intend to use. From the crime scene, there's a lot of pictures of blood. I don't actually spend that much time on the body as much. But obviously the blood and how the body cam, I plan on using one body cam small snippet, because the manner in which the victim's body is found by the police, I think, is relevant, especially to some of what I expect to be claims by the defense in terms of self-defense. The main thing with it, Your Honor, is from the autopsy, and I want to be very clear. I'm not using any of the internal photos. I'm not using, because those are irrelevant for purposes of this. I'm not using large photos of the victim's body. I didn't use any of the photos from the autopsy prior to the cleaning, because that's just got tons of blood, and I think that that gets beyond the point of where I'm going. What is important here is that the victim has a gunshot wound to his head, and there's stippling. And that stippling is important because it's a range of fire characteristic in which the medical examiner will be discussing the approximate close proximity of the barrel of the firearm to the victim's head when he's shot in the head. Now, unfortunately, because it is to his head, I wasn't able to get photos that some of them are a little bit gory. There's two that I'm thinking about, and had defense counsel asked me about it, I would have told him, because they do show the eye in a manner in which I think is a little disturbing. My plan was to either put a Post-it note over that when we show it to the jury, or even just cut that portion of it out. We can crop that down. What's important here is for the jury to be able to see how close this weapon was. And by the way, that's beneficial to both sides, because it is a fact that the victim walks towards the defendant and then the defendant shoots him in the head. That is what the jury is going to be asked about here. And so I'm going to limit it. I will also state this, Judge, you know me, I will make certain the court sees all of the photos before they go before the jury.
Gentlemen.
Judge, I received a list of the photos that Attorney Huebner intends to use. So far, I'm not sure of the photo that he's referring to regarding the stippling. There is a little bit of blood depicted in two of the photographs, maybe more than a little bit, a moderate amount. I think this will have to be determined photo by photo, like day of trial, when the photos are presented. The question is, what is the value of of that specific photograph, and what is it supposed to show other than blood? I think the state would need to assert that, and if they did, then I don't think we'd have.
Well, sorry to interrupt. The state's point is if there was stippling, I forget if it was a P or an F.
The P.
If there was stippling, the state's going to use that, I presume, to show that this was an intentional or reckless homicide because he was at close range and shot someone in the head. Is that correct, Mr. Huebner?
That's exactly what I was going to say.
And
That's relevant. That's the definition of relevant evidence. If there's stippling on someone's forehead, that means the gun was at close range.
And
That's not me saying that. That's based on testimony I've heard from dozens and dozens of experts, including medical experts and the medical examiner and others over the course of decades.
Well, I don't think we'll have a problem with it, Judge, given what Attorney Huebner stated about removing certain.
Well, why don't we just
graphic
leave it at
parts of
this? The state can use photos, obviously. To a degree, they have to use some photos to prove that there was a homicide. Each photo will be shown to me during the trial. If there's an argument on a specific photo, first of all, I expect both sides to play by the rules, and both sides know generally what the rules are. If there's an objection to a specific photo, I'll take that up during the trial. How's that?
That's fine, Judge.
Thank you, Judge.
All right. Mr. Ahmad, the issue of your client getting a haircut, has that been resolved?
It appears that in a couple of days he will get a haircut. He is aware of that date. We have spoken to the jail administration about that, so we'll confirm with the court that it in fact did happen when it happens.
Fine. The next motion in limine asks that the state be precluded from using language that assumes the defendant committed a crime by shooting the deceased. Such language, such as the use of the word victim, or that the defendant committed a, quote, crime, or that officers arrived at the crime scene, is being objected to. Mr. Huebner, you want to address that? Then I'll give the defense a chance to follow up.
Well, Your Honor, first of all, I believe I would say that the officers arrived at the homicide scene, and there's no question as to whether or not this is a homicide. The question that we're going to be apparently dealing with here is whether or not it's a justified homicide. Now, I would note, Your Honor, that in terms of referring to the defendant as the defendant, he is the defendant, but referring to the deceased as the victim, Your Honor, even in what the defense is arguing, this is not like you would potentially have in some cases where there is a question as to whether or not the crime even occurred. And therefore, if no crime occurred, or no incident occurred, or nothing happened, then therefore, there's a question as to whether or not someone's a victim. And as the court has seen some of those cases where that might be at issue. In this case, the deceased is dead. He was shot in the head. And in this case, there's not a question as to whether or not he was the victim of a homicide. It's a question as to whether or not he was the victim of a justified or unjustified homicide. So in that case, I don't believe referring to the victim as a victim in this case in any way it is prohibited. The defense shows no case law to support this contention. This court has never ruled that way in any of its cases that I've been aware of. And it might be in a situation if you were talking about, I don't know, something involving...
Right, what the state's saying, and I'll hear from the defense, is this court, as the lawyers know and as a lot of people know, presides over homicides and sexual assaults. Throw in child abuse and child pornography, and that's the entirety of my calendar. In the situation of a sexual assault, obviously there are circumstances at times where a victim or alleged victim may have made up an offense, so to be called a victim could be prejudicial. That's your argument, Mr. Huebner?
I was going to use something potentially along the lines of maybe two partners in a law office, and one says one steals money and the other says, no, I was entitled to it as part of our sharing agreement. But that would be where I would say that the argument being. In this case, referring to the deceased victim as a victim, I think is appropriate. Now,
well, let me just jump in and I'll hear from the defense, because in this case, there's no dispute, as Mr. Huebner said, that there was a homicide. And there's no dispute, correct me if I'm wrong, that your client shot Mr. Cleereman. The only question in this case is going to be, was it a homicide or was it self-defense?
Judge, that's true, but also I think the court can consider, if you want to look at alleged crimes, one could argue that alleged crimes were committed by the Cleeremans as well, in terms of reckless endangering safety or going armed with a weapon, disorderly conduct, things of that nature. So that's another basis for our request, is if they're going to use those terms, then I think it would be fair game for the defense.
Further, Your Honor, we also want to bring attention to Wisconsin Jury Instruction 805, which discusses self-defense, and it allows such actions, which we believe Mr. Edgecomb's actions would fall in, if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself. Secondly, we also want to bring to the court's attention to note that Mr. Edgecomb enjoys the presumption of innocence. We believe that no one is a victim in this case until it is proven in a court of law. That simply has not occurred at this juncture. As the court has reiterated on several occasions, this case is not to be litigated at this point. And while the facts and circumstances in this case are very unfortunate, our heart does go out to the Cleereman family, but Mr. Edgecomb, through such presumption of innocence, is as much as a victim as anyone else. The term victim crime scene is prejudicial. It would tend to be heavily influential by a jury who would likely presuppose which people have been wronged in this case. We would further caution that the court's usage of the term victim in open court or during jury instructions would tend to further violate due process, because it's suggestive that the issue is resolved against the defendant before the jury gets to decide this issue. Finally, Your Honor, there's so many different synonyms that the state could use in place of victim. They just refer to Mr. Cleereman as the decedent. He can definitely do the same at trial. And for those reasons, Your Honor, we would ask the court restrict the usage of these terms.
Mr. Huebner.
Your Honor, the Wisconsin jury instruction for homicide, if the court, and the court knows this, it states the defendant did cause the death of, and then in the jury instruction it says, insert name of victim. This is a homicide. He's a victim.
Right. Let me jump in. It's a homicide. He's a victim. Whether he was the victim of a self-defense situation or he was the victim of a reckless homicide is what the jury is to determine. And I know where this is coming from. I read the news. This is not the Rittenhouse case. I know Judge Schrader. I consider Judge Schrader a friend of mine. I have never required the state or told the state how to refer to somebody when they're on the stand. Now, if the state uses the word victim 752 times, I'll probably tell them to back off, because they'll be belaboring it. But I'm not going to tell the state how to try their case. And there was a victim in this case. There's not a dispute, as the state said, over a contract dispute amongst lawyers. It's not a sexual assault case where maybe the victim or alleged victim is making up an allegation. In this case, the state has their belief, and there was someone who was a victim of this homicide. There was a homicide. As the defense just conceded, the only question is, was it what the state charged the defendant with, or was it self-defense? And at some point, I guess we're going to come back to the information at some point, if we're doing that today or another day, Mr. Huebner. But so that's my ruling. I'm going to ask the state to draft an order after the case is over for today, based on my rulings on these motions in limine and the expert testimony. The next motion has to do with the testimony of a witness, a person who it says, and this was filed on December 28th, this individual came into contact with the defense attorneys, I'm paraphrasing, after the final pretrial hearing, specifically on December 22nd. This person allegedly saw news coverage of the pretrial hearing, which was on the 21st, and came forth allegedly with additional information. And the state's asking to introduce this woman's testimony.
Not the state.
Sorry, the defense is asking to introduce reputation evidence and evidence of conduct, instances of conduct and other acts evidence. Basically that allegedly Mr. Cleereman I mean, for the defense, it's pretty inflammatory language.
Well, Judge, I don't have to repeat it, but the motion states what that language is, and it's relevant in this case because that's what, when Mr. Edgecomb testifies, that was the same language that he had heard. So I've provided the state with the police or the accident report involving, I mean, basically, Ms. Burton has documents to prove that she had a previous motor vehicle accident with Mr. Cleereman, and during that encounter, she observed certain behaviors. In addition to that, she had known him from several different establishments on the east side, and she had opportunities to observe him, so she can testify as to his reputation and her opinion about some of his general characteristics. As to the specific act in October of 2018 involving a car collision, she stated that Mr. Cleereman was aggressive and hostile with her. He showed road rage. So that doesn't, I don't think, come under specific instances of conduct because that would have to be McMorris evidence, but it could be introduced as other acts evidence, and we're offering it for, you know, just the general MO of Mr. Cleereman in traffic encounters. This was similar to that. These two acts are similar in nature in terms of he had some sort of road rage incident with Ms. Burton involving alcohol, involving, you know, certain belligerent language, inflammatory language as well, and then apparently there were some racial slurs. His wife was also present at the time. I provided counsel with photographs even from that day. She also could testify as to his habit and routine as far as what she had observed and how many times she had seen him in bars. The state's already preemptively filed their own character witnesses, which if this evidence is introduced, then they could offer that in a rebuttal. But the state's already provided a list in case the defense seeks to do that, and we do have a witness that came forward based on her viewing things in the media. And we know that's a fact because we have the police reports of everything, in which I've turned over to counsel.
So Huebner.
Well, first of all, Your Honor, to begin with, the character evidence that the defense is attempting to bring in can only be brought in through reputation and opinion. I do not believe that the defense can establish reputation and opinion evidence. And that is because by their own submissions to what they've provided to me, this witness does not go to any of these places anymore. So whatever this reputation or opinion may have been in 2018, and I think it's highly suspect, especially considering some of the allegations that this witness has made, and I'd prefer to refer to them not on the record right now. If we need to, we can talk about it, but they're outlandish claims.
Right, I'm specifically not using the terms because, gentlemen, they're outlandish allegations. Maybe they're true, but the allegations are using incredible slurs, about the worst slur you could use against an African American and the worst slur, or one of the worst you could use against a Latino. And I'm supposed to believe that Mr. Cleereman was doing this routinely all the time in front of witnesses at bars like left and right, including about his wife. I mean, Mr. Mod, that's a very tall climb. You want me to believe that this witness that showed up on the scene a day after what was supposed to be our last hearing and now has incredibly vile, spurious allegations using two of the worst words you can use, two of the biggest pejoratives you can use against a Latino or an African American, and that Mr. Cleereman was doing this like left and right every day, all the time. That's a lot. Hang on, the state still has the floor. That's a lot for the court to swallow.
I would also note, Your Honor, that, so that's that portion. I don't believe that the defense has provided that this witness is in fact a member of the community that would know the reputation of this, of the victim in this case. They talk about the fact, as a matter of fact, she talks about the fact she stopped going to these bars according to her own claim, she's not even in a situation to know the reputation of the witness. That is why I don't think that should be allowed in, at least as it stands right now. Maybe the defense can have some more. What I am concerned specifically about is, and more so than anything else, is their attempts to bring in specific instances of conduct through this witness. And first of all, the defense needs to understand that reputation doesn't allow you to sit there and say that this person has a reputation because I saw him do this, and this. That's not reputation evidence. That specific instance, that's prohibited. So almost all of the things that the defense has put in there is this woman speaking to alleged specific instances which are not allowed, and they would not be allowed until and unless the state then introduces its own reputation and an opinion evidence, which we've noticed, and obviously then if we do so, this could be revisited. But in their case in chief, to sit here and say, well, I saw him do this one time, and I saw him do this one time, and this is how he refers to people, that specific instance, under Wisconsin state statute, that is not allowed. Reputation and opinion are very small areas in which she can just sit there and say he has a reputation for that. But even within their own, what they're talking about, it's not current. It's supposedly 4 years or 4 years ago, and additionally, and I think this is important, by someone who makes outlandish claims as to what she thought actually really happened during this homicide, and also was involved in an automobile accident with the victim. That again, and then getting to the specific instance that they're attempting to bring in as other acts of modus operandi. It's not. There was supposedly a vehicle collision between these two. Actually, there was. We have the reports on it, but nobody got shot. Nobody got punched. Nobody got attacked. How does that have any relevance to this situation in which, in this case, it wasn't the defendant driving, or sorry, it wasn't the victim driving. The defendant punched the victim, and then the victim follows him and is shot in the face. It has no relevance whatsoever to this incident. And that is why that prior altercation should not be allowed in. If they can establish reputation and opinion, which I don't think they can at this point, then that's fine, and that can be that limited testimony. But all of these horrendous allegations, some of which defy logic, I don't think should be allowed in because they are, again, specific instances, and they're not reputation and opinion.
Okay, Judge.
All right, I'll hear from the defense on the two issues, the specific instances of conduct as opposed to reputation and opinion, but go ahead.
Judge, first, of course, the court can voir dire this witness, and we can ask in more detail about how well she knows Mr. Cleereman. From what I understood from her, she's known him for over 20 years, and she knew him in the bar community. She described him as a bar fly. So some of the places that she frequented where she would know him and see him was Why Not Tavern, Coffee Tales, etc. That's part of the habit and routine practice, as well as going to his reputation within that community and her opinion of him as far as her observations. The specific instance from October
Well, then,
28th.
okay, hang on. So she's known the guy for 20 years, and yet she didn't come upon this alleged information until after this case has been litigated for 6 or 7 months, after multiple news conferences, some that have been held by the defense, some statements by the victim's family. She, lo and behold, came across all of this on December 22nd, way after a year after this was originally charged, way after a year after this incident, and after your client's been in custody for 6 or 7 months, on literally the eve of the trial. She stumbled across this.
It wasn't the eve, it was the 21st or 22nd, Judge. And
Right,
yes,
but
we haven't had,
intervening in those 10 days was Christmas, New Year's, and 2 weekends.
Judge, she's an elderly lady. She's probably in her 60s. That was the first time we've ever heard of her. I had no knowledge of Miss Burton, but she had provided us with reports about it.
Mr. Ahmad, first of all, 60s is not elderly. As someone who's getting dangerously close to 60, let's not use pejoratives like that.
I apologize, John. I didn't mean it that way. I'm just saying she was unknown to our office or to Attorney Lamar. I have never met or heard of Miss Burton. She had come forward after she had seen the video in this case, which was recently released and was not known to the public. But after coverage in this case, there was significant coverage on the 21st. She happened to see that and called her office the next day. And that's been, from that point on, the only contact we've had of her. I think that for more clarity, you certainly could voir dire Miss Burton as to more details as to how she knows him and the reputation. I think the standard is not as high as what the state's saying here. If she viewed him in a bar where he was intoxicated, then I think that these so-called outlandish claims are not that outlandish.
Wait a minute, but that would be a specific instance. You can't bring in specific instance. You have to bring in reputation or opinion.
Right, I agree with that. And so I'm not going to make a blanket ruling today regarding Ms. Burton, B-U-R-T-O-N. If it comes to that during the trial, if there's a possibility at some point of the defense introducing reputation and opinion evidence regarding Mr. Cleereman, not specific instances, we can voir dire, or I will voir dire the witness with the assistance of the lawyers outside the presence of the jury. It's a little hard for me to rule on this exact evidence because I don't know exactly what she would testify to, though there is basically an offer of proof in the defense motion. So I'm not barring Ms. Burton, but before she were to take the stand, she would have to be voir dired by the court and the attorneys, and she may be allowed to testify. She may be allowed to testify on certain topics only, or she may not be allowed to testify depending on what I hear. So that's my ruling on her situation. That brings us to the motions eliminae that were filed on December 31st. The first one's regarding testimony from Detective Fraley, F-R-A-L-E-Y, or Ruby, R-U-B-I-E, Mizell, M-I-Z-E-L-L. There's also testimony potentially from a Detective Kirkvold, K-I-R-K-V-O-L-D, testimony from a Kentucky State Trooper, and others. Since the defense filed and I read it, I'll hear from the state first, specifically as to what might be introduced by Detective Fraley, Detective Kirkvold, or others.
Okay, so let me get to the first portion, which is sub A, which is Guy Fraley and Miss Mizzle. I don't plan to introduce any of that. Whether or not there was any allegations of domestic abuse towards Miss Mizzle, I would not do so in my case in chief, except, and this would be the only possible way it could come in, that's if there is not a stipulation to the fact that the defendant was out on bail. Because this allegation, first of all, there was a charged case involving domestic violence as well as well, involving domestic violence. That is when the defendant was out on bail for that case with a no weapons order and then didn't come to court. That's what's going on. So if there is in fact a stipulation to the fact that the defendant was out on bail, then I do not need to prove the fact that he had an open felony case with the condition that he not have a weapon. That would be the only way. I don't see anything in that unless someone calls Miss Mizzle, and then that would be something that maybe we would have to deal with outside the presence of the jury. But I can tell you that I do not envision attempting to introduce this prior domestic violence incident as to having any relevance, except for in that it may affect Ms. Mizzle's testimony, but I don't see that being a factor here, especially if there is a stipulation. Now, I have drafted that stipulation pursuant to Old Chief, in which the defense, if they do want me to enter into that stipulation, can prevent me from letting the jury know the nature of all the underlying charges. It would be he was just out on one felony bail, he was out on one misdemeanor bail, he had the condition, he knew about that, and that's it. And then we'd be done. And then everything that they're talking about in regards to sub 1 and sub A, I don't see how it comes in.
All right, well, before we get to the rest of it, the Kentucky officer and Detective Kirkvold, what's the status on that, gentlemen? Everything Mr. Huebner just raised?
Regarding the stipulation, I think that's something that we could deal with on the day of trial, Judge. It was something that I was also wanting to discuss in chambers.
All right, we can potentially do that in a minute.
All right.
But let's talk about Detective Kirkvold and the Kentucky State Patrol officer.
Your Honor, first of all, regarding the nature and circumstances of the traffic stop, I don't plan to be getting into that. What was found inside the defendant's vehicle, I don't plan to be getting into that, other than when they do a search of the vehicle, they find his ID card, which is how they know that he lied to them. And, Your Honor, you have already ruled, pursuant to consciousness of guilt evidence, that when the defendant flees the state, that's consciousness of guilt. I included in my motion this very conduct, that when the defendant, and we talked about it a lot at the last hearing, and the court ruled within parameters it can come in. When the defendant is stopped, by the way, and I think this is very clear, he's stopped in a vehicle, a rented vehicle, that is rented by Ruby Mizzle, who he had no contact order with, but it's rented by her. He states that he is going from Texas to Kentucky. That's not true. And he also, when asked for a name, says he does not have identification and provides a false name and states that he was licensed outside the country in the Bahamas. All of that, Your Honor, I think is clear consciousness of guilt information, because the defendant is attempting to avoid being captured for this homicide. And that is important, as the court has already ruled. Consciousness of guilt evidence is important for the jury to determine whether or not the defendant is being sincere in regarding his claims of self-defense. The fact, as the court has said, had the defendant stayed on scene, called 911, done all of those things, that'd be one thing that the state would have to deal with, and the defense would be making a big hay out of that, and I would have no argument to keep that out. The same is, the reverse is the same here. This defendant left the scene, then he left the city, then he left the state, and when someone pulled him over, he lied about his name. Lying about his name, I'm not going to make a big deal out of it, but at least the fact that he lied about his name and claimed that he was from another country is relevant for this jury to understand that he did not, in fact, believe he was operating in self-defense. He was trying to get away with it.
Counsel?
Judge, the court's already noted previously at the last hearing that there may be another reason for his flight, which is what the defense intends to put on at trial. There was another reason for his flight, which we know what that is. It pertains to the other bail jumping charges. In this case, I know counsel told me he already agreed that we're not going to get, well, that's also pertaining to the same incident with the trooper and Detective Kirkvold. That is letter C. As far as, you know, what is the scope? This is what we had mentioned at the previous pretrial hearing. is how detailed are we going to get into this after the fact conduct? How probative is that? How much time is the state going to spend on everything that transpired after? Because none of this stuff relates to the 24 seconds, we see in the video before the shooting. I think the parameters got to be narrowed here. We're talking about some of these small little details. At some point, it's just going to become very cumulative.
Well, as far as that testimony, I mean, yes, I ruled that the consciousness, the flight, concealment, consciousness of guilt evidence can come in. It's pretty black letter law. There's a jury instruction that specifically discusses the impact or lack of impact of, again, flight, concealment, consciousness of guilt. I'll allow the state to talk about it, but in brief form, the state's not going to belabor it. We're not going to get into all the circumstances of the arrest or what led up to the arrest, but the fact that the defendant was apparently apprehended by all accounts in Kentucky, that he allegedly may have had a false information or not had an identification or given a false name, that's relevant to the state's attempt to prove that this was a homicide. It's relevant to consciousness of guilt. Again, because I said this at the last hearing, but as Mr. Huebner was just referencing, in a case that I tried within the last 6 months, a self-defense case, that was the opposite. All the other evidence came in. That evidence happened to be helpful for the defense, but in that case, the defendant stayed on the scene, called 911, applied pressure to the wound, turned himself in, and made an immediate statement that this was self-defense. In this case, your client fled, apparently, left the state, went 5 or 6 states away, was on the lam for 6 months, and then told the police he was a different person when he was apprehended. That's also relevant. It cuts both ways. Anything else we need to address today, gentlemen? And by the way,
Yes.
Unless it's an emergency, I don't want any more motions filed in this. The trial starts next week. I don't want to see a new motion come in every single day between now and next Tuesday, unless it's an emergency that I need to deal with, and I'll deal with it on the day of trial. That goes to both sides.
Yes, Your Honor. The only other thing, Your Honor, that I think should be addressed is the next portion, which is sub C of their motions in limine. And this is the situation, and I just want to be very clear, because the motion in limine has some facts, and I want to explain it. And if necessary, again, I'm willing to play this small portion. It's about 30 seconds of an audio tape for the jury in chambers, just in case the court rules that it can't come in. But what happens is detectives go down to speak to the defendant. Prior to reading him his rights, they're asking him the questions the court knows that they ask. Are you on medication? Are you drunk? Do you understand what we're talking? All the various questions detectives ask for one purpose and one purpose only, which is to make certain that the guy understands his rights and understands what they're talking about, so that prior to reading him his rights, and if he waives those rights, they know he understands his rights and they're reading them. And if they just walked in, read him his rights, and the guy said yes, then the defense would be all up in arms saying, well, you didn't make certain that he understood English. So in this situation, they're asking them those questions. The defendant says, well, I want to know what you're here for, or words to that effect. The detectives, after making certain...
The defendant says to the officers, what?
Detectives. Basically, words to the effect of, well, I want to know who you are and why you're here. So the detectives then identify themselves as Milwaukee police detectives and state, we want to talk to you about what happened in Milwaukee. And as the defense puts in their brief, he responds, what happened in Milwaukee? Now, I want to be very clear about this. The detectives are not asking a question designed to elicit an incriminating response. They are, at that moment, simply identifying who they are and what they are there to talk to the defendant about. The defendant then responds, well, what happened in Milwaukee? Right after that, they read him his rights. He asks for a lawyer. It goes no further. It's done. I'm not going to, under any circumstance, and the court knows this, I am not under any circumstance going to bring in the fact that he decided not to answer any questions or talk to the police. I can't. That's his constitutional right. I won't even touch it. Now, then I've told this to defense counsel, this is where this gets a little bit potentially problematic, but I still think it's okay. Because in this situation, the defendant, who is now claiming self-defense, has two detectives sit down and state, we want to talk to you about what happened in Milwaukee. And the defendant, who is on the run from that incident, acts as though he has no idea what they're talking about. I think that that is relevant. Now, I would argue that potentially it's relevance in my case in chief. I could see the court saying, look, it ends up getting into an area in which the jury could be led to believe, it could end up touching on his right to remain silent. So I'm not even seeking to introduce it in my case in chief. I don't want that. But if he takes the stand and he starts saying that he was acting in self-defense, I do believe one or two questions about the fact that when detectives walked down and said they wanted to talk to him about what happened in Milwaukee, and he responded what happened in Milwaukee as though he did not know, is relevant for the jury to understand for the same reason. I don't believe I can go any further than that. I don't believe I can make any other argument other than he was provided an opportunity and he acted cute, and that's it. I don't necessarily know that the court has to make the ruling now because I'm not seeking to introduce it in my case in chief. But if the defendant takes the stand, I do believe that in this situation, when the detectives identify themselves and state what happened they want to talk to him about Milwaukee, and he acts as though he has no clue about an incident in which he shot someone in the face, I think that's relevant for his credibility. And I would simply note, defense counsel objects saying, well, he wasn't giving us Miranda warnings. Miranda would matter if I was attempting to bring it into my case in chief. They're not arguing this is a good child violation. They are not arguing that this is coercive. And it is that prevents me from using it in rebuttal or in terms of impeachment of the defendant's testimony. And it is that reason why, Your Honor, if the defendant testifies, I should be allowed to use this small portion in a limited fashion under the strict guidelines we've just talked about.
Judge, I think if he were to say, no, I didn't do it, then it would be proper rebuttal. But that's not what this is about, right? These are just statements that are a question that's asked by the client. He doesn't know who the detectives are. They've come all the way from Milwaukee to Kentucky. I mean, the states agree that they're not going to introduce it in their case in chief. As to its relevance, I think it would only be relevant if he said, yeah, I'm not the person who did it. That's not what this defense is about. So I don't see why it needs to come in, because this is all pre-Miranda.
Well, I think that's one I can table until the trial. The state said they're not going to use it in their case in chief. If the defendant testifies, it may or may not be a legitimate brief inquiry of a question or two by the state on rebuttal if the defendant testifies, but I don't think I need to rule on that today, so I'll take that issue under advisement and deal with it as the trial is progressing after I see what's been asked. Is the defendant testifying? And we can deal with that then. Any other issues from either side we should be dealing with today? And just so I'm clear, if there's something of an emergent nature, fine. I have no problem with either side filing a document or a motion. I just don't want continued, every 3 days between now and next Tuesday when the case is going to start, or we're going to start voir dire. Mr. Huebner, anything else from the state?
Amended information.
All right, do you want to make a record on that? I know we discussed that off the record with the attorneys. I believe the defense is aware of this situation, but if you can make a record on that, please.
Your Honor, from the very beginning, I have told the defense that if we were to try this case, I would be filing an amended information. I filed it several months ago, I believe, I think in November, if I'm not mistaken. We've put it off until the final pretrial. We ran out of time at the last final pretrial. Then the jury trial, we know what happened there. So we have the opportunity now. It is timely. It is related to the charges for which the defendant was originally charged. I think it's a proper filing. I don't believe the defense is objecting, so I think we should, because I don't believe there are grounds to object. So I think we should do the arraignment of the amended information.
Judge, I am not stipulating to that. I know we've talked about it multiple times. In this case, we have a video which shows a threat of force and then Mr. Edgecomb's response to that. Now, whether that was reasonable or not, that's a jury question. But for the state to try to allege when we know for a fact there was self-defense involved, whether that's unreasonable or reasonable, again, that's a jury question. we have at most a second-degree reckless homicide.
He shot a person in the face, and that's a jury question. And by the way, all that matters at this point is whether or not probable cause of a felony was found. At that point, any felony that is wholly related to the incident is allowed. The defendant took a gun and he shot a person at close range in the head. Whether or not that is intentional or reckless, first or second, is something the jury can consider. The state is well within its right. The defense has been placed on notice. There is no prejudice to the defendant in terms of the filing of this information, and that is why it should be allowed in at this time.
And Judge, I misspoke. I meant second-degree intentional homicide, when there's an unreasonable amount of force used. That's what the state is alleging here, so they can charge that.
That's not what I'm alleging. I'm alleging first-degree intentional.
All right, just for the record, before you continue to argue, the state has filed an amended information. We did discuss this at least once on the record, and I know it's been discussed off the record, that the state was intending to, or at least considering filing an amended information. The amended information charges the defendant with first-degree intentional homicide, use of a dangerous weapon. That's count 1. Count 2, bail jumping as a felony, and count 3, bail jumping as a misdemeanor. Obviously, it modifies count 1. It does not modify count 2 or 3. Obviously, the defense has their own position in terms of what occurred or did not occur here today, or strike that, what occurred or what did not occur on the date in question, September 22nd of 2020. But beyond that, I think the state's correct. I can't even conceive of a reason I could or would prevent the state from filing an amended information. It happens routinely in Milwaukee. Sometimes amended informations modify the charges up. Sometimes they modify them down. Sometimes an amended information adds additional charges. It's just sort of par for the course. But Mr. Ahmad, what would the objection be?
Well, Judge, in addition to what I've stated, that at best this is a second-degree intentional homicide, I feel like this is a sort of trial tax. I mean, Mr. Edgecomb does have the right. This case was charged as a reckless homicide, and now the defense, has about 15 witnesses. We are on the eve of trial. I know that we were provided notice, but this tactic, I think, a case should be charged the way it is and not increased in penalty just because the defendant wants a trial and has a right to be heard, especially in a self-defense case. So that is a different case altogether, and I think somebody's rights for due process should be respected, that they should be given a trial when they're saying this was in self-defense. And now Mr. Edgecomb is going to face a first-degree intentional homicide charge that carries a mandatory life sentence if he's convicted. And it just ups the stakes. But we are going to proceed to trial, Judge, as planned next week.
Mr. Hubner, you want to make a record on it, please?
Your Honor, what defense counsel is basically requesting is that the state, if we were to follow what he just stated, to file every single charge possible at the highest level every single time we issue a case. That's not appropriate. That would be an abuse of discretion. In this case, I issued a charge that I believed, starting off with a first-degree reckless. I have been very clear, as the court knows, that in those situations, I am willing to negotiate. But if this goes to trial, I am going to try it as a first-degree intentional. The defense is that he intended to kill somebody. So I don't understand how this is any situation other than a first-degree intentional. That's what we have to deal with. I cannot issue a second-degree intentional, although a jury could convict of that if they so choose, because I cannot concede under the statute that I am unable to prove first-degree intentional. That's what I have to concede. I don't, because I do not believe I cannot prove first-degree intentional. So I cannot issue a second-degree intentional because I cannot concede that in good faith. I do not believe it. I don't believe the evidence supports it. Here's what matters. When a preliminary hearing happens, a commissioner finds probable cause of a felony. The state then is able to issue all felonies that are wholly related. Clearly, first-degree intentional homicide is related to first-degree reckless homicide. It's an appropriate charge. In this case, the only objection the defense could make is if they did not have notice. They've had notice for months that this was coming. There is no reason not to allow the filing of this information.
And Judge, just for the record, we are not alleging that he intended to kill him. He intended to act in self-defense or intended to shoot. Those are two different things.
Right, but in any event, the state's correct. The state can file an amended information. I know that the state has told me and told the attorneys previously on more than one occasion that if this case is not resolved, the state intended to modify the charge from first-degree reckless homicide to first-degree intentional homicide. They filed the amended information. The defense has had notice. Count 2 and count 3 remain the same. The circumstances, the incident in this case, the witnesses, how this situation went down with the shot being fired by Mr. Edgecomb, allegedly, though again, everyone pretty much agrees on what occurred. The dispute is whether it was a homicide, first degree intentional, first degree reckless, or otherwise, or if it was self-defense. So noting the objection, I'm allowing for the filing of the amended information. Counsel, you'll waive reading, I presume?
Yes, and we would enter a not guilty plea at this time.
All right, I'll accept the waiver of the reading. I'll accept the not guilty plea on behalf of the defendant on counts 1, 2, and 3. Again, it's only count 1 that's being modified. In terms of the trial, gentlemen, I will plan that next Tuesday will be the same as if it was a Monday. We'll pick a jury. I have just 1 or 2 other cases to call next Tuesday. I'm going to bring up a jury of hopefully 45 or 50 people. Just like I had planned last week, we will not do jury selection in this courtroom. We will most likely do it in room 500 of the courthouse, but I will, or my clerk will advise you as to where voir dire is going to occur, probably in room 500 of the courthouse, but certainly in a courtroom that's larger than this one to accommodate the extra jurors. After the jury is seated, and I'm planning on keeping 14, I'll keep 12 plus 2 alternates. We'll obviously start with openings, testimony. I don't need a final answer, but from both sides, Mr. Huebner and from the defense, generally, how long are you anticipating that once we seat a jury, the trial taking in terms of days and witnesses?
One moment. Let me pull up my notes on that issue.
And Judge, we do have a few more issues to discuss before we recess.
I thought we were getting to the end, but okay.
Your Honor, in terms of your question, I have myself right now at anywhere between 19 and 20, 21 witnesses, so I think we'll probably go till Friday. I think if the defense is at least going to call the defendant, I think there's a chance that we go into the following Monday.
All right, I don't need a final answer. That was what I was anticipating Friday, possibly rolling it over to the following Monday. Mr. Ahmad, anything else you said?
Yeah, Your Honor, we have a couple issues. First being wanting to take a proactive approach as it relates to the COVID issues that remain. We would ask the court for a provision or order for any witnesses that contract COVID and have a positive test or positive reading, that the court would so allow those witnesses to testify remotely in that instance. That was the first. The second is, as the court is aware, we do have a forensic expert relating to the video, and we would also ask the court to allow him to testify remotely as well if possible.
Well, as far as COVID and any witnesses testifying, that could be a problem, but it's a possibility, I guess. Mr. Huebner?
Well, first of all,
I'm not ruling on it yet, but go ahead.
I understand that, Judge. I think it might be a little too early for us to tell, but the defense needs to understand that whether or not witnesses testify remotely is a constitutional right your client holds. And so he would have to give up his constitutional right to confront the witnesses in front of him. So we would have to, before we could make any ruling, have to have a colloquy with the defendant that he is giving up a constitutional right. Because that's what's happening there. I don't have a problem with it if we
That's correct. And not only is it constitutional, I believe there's a statute that addresses that exact issue.
There is.
That says, that says the defendant has to affirmatively waive his right to have a witness, any witness that's testifying against him, or I guess even for him, not be present in person, which obviously facilitates more easily effective confrontation and cross-examination. Go ahead.
I would note, Your Honor, the very first trial that we tried to do in your court back in 2021 or 20 sometime, if the court remembers, we ran into a detective that wasn't allowed in, and we tried to set up, and it involved us having to set up, and if the court remembers, I was in here and I ended up setting up 3 different computers with 2 different Zooms working to make certain that the witness would then be able to also view the exhibits. Because that's the main thing you have, is that not only are they testifying, but we have to make certain that what they're seeing is exactly what the jury gets. So in terms of...
And I have to be sure that they're not seeing something they shouldn't be seeing, which is a concern for the court and should be a concern for the defense, because depending on who the witness is, I don't want them looking to, reading or referring to something that they would not be able to refer to in front of me because they happen to be on a Zoom screen. But go ahead.
I can, in terms of any of the state's witnesses, if that is something the defendant, the constitutional right the defendant's willing to give up, I believe I have set up a system that we can do it. I would note in terms of the defense expert, I'm willing to talk to the defense about that. I keep saying that if they'll just explain to me what was done, we may not even have an issue on that. The main thing with it is, in terms of him testifying, I don't necessarily have a problem with it being over Zoom, as long as we make certain that what he is showing is what we are introducing in evidence here. It can't be something from his computer. It has to be something that we introduce from this computer and is moved into evidence from here.
Which expert are we referring to?
That's going to be the video expert, I think.
It's Mark Robinson, I believe. We provided the state a copy, a side-by-side.
Hang on.
Mark Robinson. We have provided the state a side-by-side of the video, which obviously there's not many changes at all. The only thing that's really changed is just a little bit brighter to give clarity so that it's easier for the jurors to be able to see. But that's really the only change. And like I said, the state has been in possession of that for at least 2-3 weeks now.
And I have been, but I would note that the defense keeps asking me to stipulate to it, and I've stated I'd be willing to if they'll just tell me exactly what was done to it, so I can make certain that what was done to what they're saying was done to it, I can recreate or talk to my people. I haven't been told it. If they either let me talk to the expert and he can walk me through it, or, tell me exactly what they did to it. All I've got is 2 videos, and I have no idea what has been added or changed to a video that we got from the actual source. And that's my concern, because I don't know what has been done to it. I'm sure, and look, I assume the defense attorneys are like me. They probably don't know, because it's a tech thing. I mean, no, we don't know it. I just want somebody to sit there and say, I use this program. Then I can go to a guy that actually understands computers, and he can tell me whether or not, what changes that have, and then I'll let you know if I have an objection or not. I don't think I will. I just want to know what I'm agreeing to.
Your Honor, as we said before, we provided the state a copy of side-by-side. There's no material changes whatsoever. I'm happy to arrange a conference or call this week with the state so that he can, hear from the expert himself. Again, there's no material changes. The only thing that you can really see is that the video is simply brighter. That's about it. But yeah, we're happy to arrange that.
Hang on, let me jump in. Then you guys work on it. You guys discuss it. Try to come to a stipulation or an agreement so that I don't have to rule on that particular issue. I'd prefer to avoid testimony that's not in person for all kinds of reasons. I would have to have a colloquy with the defendant. Obviously, if that was to occur with any of the witnesses, particularly the person we're talking about, including this potential expert witness. But you guys talk about it, figure it out. Well, let's try to have it resolved by next week so we don't have to argue about this next Tuesday.
Thank you. Anything else, guys?
Yes. Judge, given the realities of COVID and what's going to happen next week during voir dire, I want to know if the court would allow us to submit a proposed jury questionnaire. Given the severity of this case, I mean, it's not something I normally would request, but given the realities of where we're at, it might make voir dire a bit smoother. I can imagine there's going to be all kinds of logistical issues with the voir dire of 50 or 60 people on the panel.
Your Honor.
Well, there are some potential logistical issues, yes, and there are logistical issues and issues related to COVID, which are unfortunate, but Mr. Hubner?
Your Honor, I would just simply note, I've done cases where there are jury questionnaires. Personally, I find them, I don't know how helpful they are all the time, but one of the things that we require is then you have to get all the 50 people in a pool. Then we have to go down there with the defendant. And because the defendant has a right to be there when we have all of these confrontations, or all these talks with the jury. Then we have to provide them the jury questionnaire. Then we have to
Let
provide
me
them.
jump in, all of which is not going to happen in Milwaukee County. It's just not going to happen. If the defense and the state, or either, want to submit a few questions that the court would ask from the bench for voir dire, I'm fine with that. Mr. Mott and Mr. Huebner have had trials with me. You know that generally I stay out of voir dire. I introduce the basics of the case. I tell them how long the case is expected to go. I read the allegations. I ask some basic questions. Then I have each of the prospective jurors do their pedigree questions, meaning their juror number, where they live, their occupation, have they been on a jury before. I do all that kind of thing. If either side has a few questions, meaning up to 5 or 6 that you might want me to ask because you would feel it's better coming from the bench as opposed to one side or the other, I'm fine with doing that. But in terms of other issues, I mean, Mr. Huebner's correct. I'm not going to know who the 45 or 50 jurors are until they show up in court next Tuesday. Working with jury management in Milwaukee, they have their challenges, I'm sure, but it's not always particularly smooth and particularly easy. So again, I'm going to keep 14, 12 plus 2 alternates. I expect voir dire to be done on Tuesday, certainly. I'm not going to let voir dire drag on for days or even innumerable hours. I expect both sides to get to the point to ask appropriate questions that are appropriate for voir dire. And if either side wants to submit 5 or 6 questions, or for that matter, 2 or 3 that you might want me to ask, that's fine. I'll consider that, and we can take that up further Tuesday.
Judge, with regards to alternates, I think it'd be a good idea to have more than 2, just because, let's say someone contracts COVID.
Mr. Mott, if somebody on the jury panel contracts COVID, the toilet, unfortunately, the case will go down the toilet. It'll be a mistrial because there's no way, if I have 14 jurors that are sitting next to each other, even with plexiglass, that's going to go forward. It would be very, very unfortunate, but I think 14 is appropriate. So state want to weigh in on that. I mean, COVID's a problem. I mean, I don't need to belabor my situation from last week. I read an article, I think in the New York Times, that referred to last week as the week that all of America called in sick because everybody and their brother, including multiple Bucks players, Mike Budenholzer, NFL players, everybody, it seems, either was positive themselves in the last 2 weeks or knew somebody that was. There's also been outbreaks in the jail, in the House of Corrections, in the DOC. Hopefully that does not affect Mr. Edgecomb, but some of this has to be a game day decision. So I'm going to keep 14. I think that's plenty. It's adequate for a trial. It should be done in a week, whether that's Friday or the following Monday. Anything else in the defense?
Yes, Judge. We did file an objection to jury instruction 815. I did talk to counsel about this. I think at this time it's premature technically because we have to review all the evidence before we get to jury instructions and what's appropriate. But essentially we know what the basic facts are. And the issue from 815 is whether or not to give that instruction. In this case, we know that there was retreat and there was notice of that. So it kind of cancels, given that the defendant regained the right to self-defense, it kind of cancels out the necessity of 815. And it just, we can listen to the evidence and then make a ruling, but that is essentially what our argument is. I don't expect that to change.
I'll listen to the evidence. I'll make a ruling after we hear the evidence. Mr. Huebner, anything else?
No.
Mr. Mott?
And then, Judge, just for the record, I want to make the argument that, again, consciousness of guilt evidence can't be reconciled with jury instruction 805, which just says, you're not to evaluate the case from your viewpoint now. You got to look at it from his viewpoint at the time that the force is used. So I don't see what he did after really matters according to the law of self-defense. I understand the state is going to put that evidence in any sort of case they can where flight's involved, but then when there's an affirmative defense, and then that's what the instruction says, how do you reconcile the two instructions? Would say, don't look at this in hindsight, but then we want you to consider everything after the fact. I mean, how does that logically make any sense?
Mr. Huberry, can I have last word, then we're done.
Your Honor, consciousness of guilt is what the defendant did in terms of his mindset. The moment he committed this act, he took off running. That goes to show, in terms of what he actually and reasonably believed, he knew that it wasn't self-defense, because he took off, and he kept taking off. And the only reason he's even here is because Kentucky trooper pulled him over and then happened to find his driver's license when he lied about the country he was from. That's consciousness of guilt, because he is telling us by his own actions that it was not self-defense.
Judge, we've heard the same argument over and over.
Right, I've heard the same argument from both sides. In terms of jury instructions, we'll deal with jury instructions when we get to that point, which will be next Thursday or Friday. Maybe Monday, but hopefully next Thursday or Friday. All right, we're adjourned. Thank you.
Can I get out, or do you need me to wait? Sounds good. I'm going now.
Because they're changing the charge now.
No, it has to be an update because it's an update to the charge.
So you want to take them back by yourself? Catherine, might I say that's a fantastic seat? Oh, thank you. Where did you get it? Can you give them, were you using command? Okay. Were you using command or using? No. Bring them up together?
We brought them both up together, but we just had them regular handcuffed.
Are we allowed to use the two hands still or no?
I didn't bring them up, but.
We're gonna use a two-man team.
Okay, I've never used that one before.
You gotta learn it.
I mean, what's the difference if you're standing together or you get together?
Zach, I don't, the rules keep changing and they don't tell me.
Yeah, I don't know.
Well.
Maybe a little bit. No, I don't.